The United Nations is founded on the idea that public good can only be achieved by a system of international law that mandates peace, prohibits war, and ensures that all individuals are entitled to the means to live in freedom and dignity. In the past 65 years, 2 interdependent bodies of international law were developed through the creation of international conventions and instruments. The first body, human rights law, promoted the concept that all individuals are entitled to certain fundamental rights and are entitled to have those rights protected by their governments. The second law, humanitarian law, as a body of law that prohibits war, makes genocide and torture international crimes, and restricts states' conduct of military operations through the creation of war crimes, crimes against humanity, and breaches of the Geneva Conventions. The rights and prohibitions contained in these international instruments have all become part of the domestic law of states such as Canada, through the country signing and ratifying the international instruments and then passing domestic laws making those things crimes. Both of these branches of law resulted in the creation of criminal sanctions that potentially radically alter, firstly, the sovereign right of states to conduct their affairs free from the legal interference by other states and free from legal consequences imposed by other states. And secondly, they radically alter the duty of states to prevent and punish violations of internationally protected rights that occur outside their territories. Also, under these laws, individuals for the first time became personally liable for crimes. Following orders of a superior is no longer a defense, and there's no longer any immunity accorded to heads of state or other high-ranking officials. These laws also radically alter states' duties and their right to prosecute crimes committed outside their territory. Laws previously in place allowed states only to prosecute offenses that occurred within the state or offenses committed by one of their citizens, and in some cases, crimes against one of their citizens. Otherwise, a state had no jurisdiction to prosecute crimes. Also, previously, heads of state and other high officials were immune from civil or criminal liability for crimes carried out in their official capacities. For example, crimes carried out as part of a state policy or under the rubric of necessity occasioned by or characterized as war or national emergency. Now, just to tell you, the term crimes against humanity refers to certain acts committed as part of a widespread or systematic attack directed against any civilian population, and the term war crimes refers to certain acts committed as part of a plan or policy or as part of a large-scale commission of such crimes. Enforcement of the laws that prohibit genocide, torture, prohibit grave breaches of the Geneva Conventions, war crimes, and crimes against humanity by investigation and prosecution is primarily, and in many cases solely, the duty of individual states through their domestic criminal law systems, and many people don't know that. Canada and other states ratifying conventions such as the Geneva Conventions, the Rome Statute of the International Criminal Court, and the Convention Against Torture have expanded their criminal jurisdiction to enable courts to prosecute crimes wherever the crimes are committed, irrespective of the nationality of the victims and the alleged perpetrators. UN monitoring bodies have no enforcement powers whatsoever. The International Criminal Court, many people think that, oh well, the International Criminal Court should get busy and prosecute these people. It's important to understand that the International Criminal Court is a court of last resort. The International Criminal Court has jurisdiction only when one of 3 conditions exists. Number 1, the accused is a national of a state party, in other words, a country that has signed and ratified the Rome Statute, which, for example, the US and Israel have not signed and ratified, or the crime took place on the territory, in the territory of a state party, or the United Nations Security Council has referred the matter to the International Criminal Court prosecutor. Now, even when one of those conditions is satisfied, the International Criminal Court still is not supposed to act to prosecute unless there is no domestic court that is both willing and able to prosecute the crime. Now, an example of a state duty to enforce the law, and in this case of a state's duty so far to fail to enforce the law, is Canada with respect to torture. In 1985, Canada passed the Geneva Conventions Act as part of its duty in ratifying the Geneva Conventions, and that act makes torture and other grave breaches a crime in Canada no matter where it was committed. In 1987, Canada ratified the Convention Against Torture and passed provisions of the Criminal Code making torture, wherever it occurred, a crime in Canada. In 2000, Canada passed the Crimes Against Humanity and War Crimes Act. That also made torture a crime no matter where it was occurred and who committed it, and again, whoever the victim, a crime in Canada. Canada also has a duty under the Geneva Conventions Act and the Convention Against Torture to take all effective steps to make sure that people suspected of torture, and this is to assist the prosecution of alleged tortures by other jurisdictions, to assist that people suspected of torture don't have a safe haven from prosecution or detention in Canada. And to ensure that they could fulfill that responsibility, the Canadian Parliament passed the inadmissibility provisions of the Immigration and Refugee Protection Act. Those laws provide that when a person believed on reasonable grounds to be complicit in torture enters Canada, or when the victim of torture is a Canadian citizen, the torture alleged is deemed to have been committed in Canada and has to be investigated and prosecuted as such. So to give an example, the torture of Omar Khadr by making him a victim of the so-called frequent flyer program in Guantanamo Bay is deemed to have been committed in Canada, even if none of the Bush administration people ever came to Canada, by virtue of the fact that Omar Khadr is a Canadian citizen. So we see that there are laws in place internationally and domestically that criminalize all of these atrocious acts. We also see that as yet there's no significant enforcement of these laws. While evidence of crimes committed by the US, the UK, and other coalition members in Iraq and other NATO members in Afghanistan continues to mount, the political will at present is clearly, this is certainly demonstrated in Canada, to take effective measures to block investigations and prosecutions rather than to enable them. In most countries, the law and enforcement mechanisms are firmly in the control of elected officials, and therefore, in the absence of political will, there has been and will be no reliable and effective enforcement. For example, again in Canada, the Attorney General of Canada or his deputy must give, I'm going to use the pronoun applying to who we have, his written approval to the commencement of any prosecution for war crimes or other crimes against non-Canadian, or for crimes that occurred outside of Canada. The only provision in Canada that doesn't require the prior written approval is the Criminal Code torture provisions, and the Attorney General of Canada must give his written permission for prosecution to proceed within 8 days of an information being laid.